Thank you for being here. I'm Scott Collins, the owner of Elder Law Guidance in Richmond and an elder law attorney here in Kentucky. And we're talking about trust tonight. Everything you ever wanted to know, plus a little bit more. After tonight, I think you'll be ready to pass the bar. What kind of a promise is that? Huh? I don't want to. Never mind. I'm with you. Who would want to do that boring stuff? So you should be seeing a slide now that covers the entire screen and gives our topic for tonight. Trusts a better option than a will, or a question mark. Is that true? Is it not true? I'm going to answer that question and talk about the various types of trust and concerns that we may have about using them and some of the advantages of using them. I'll also talk about wills as well. So I want to get some preliminary stuff out of the way first. As I've already said, the purpose of this webinar is to simply educate you. I'm going to say a lot of things. It's impossible for me to tell you everything you know. So if you take something I'm saying tonight and rush off and apply it, it's not everything you need to know. Mistakes will still happen. So please just take this to be nothing more than just educational. You still need to talk to an attorney. If you don't like me, I'm too ugly, I'm too skinny, I'm too bald, I don't care. Find somebody else that can help you and talk to them. It's very important you have a live attorney to apply these things to your case, your situation, your family. But if you have questions, I'm happy to entertain questions, because what's the use of some educational material if it's still confusing to you? So I'll do everything I can to help you. If you'll just drop it in chat, raise a hand and talk to me about those things. There are no silly questions. I promise you that if you are asking something, there's somebody else here that has the same question on their mind too. So please ask. Let me tell you a little bit about me. I'm former Army air traffic controller. I left the Army after I had several children, decided my heart needed to be given to church work, and so I became a minister, and I did that nearly 20 years. Thank you for thinking I'm too young to do that, but I'm old enough to have done quite a long time in military tours and then church work. Because of some personal needs, I had to walk away from church work and decided that I wanted to take what I had learned through counseling with families, so many funerals, hospital visitation. I've sat with people in death and dying circumstances since 1991. And I wanted to go into law so I could help people deal with those difficult situations in a real concrete way. And so law seemed a good fit. And since I did that, I've worked very hard to specialize in the area of elder law. I focus exclusively on it. I have been the chair of Kentucky's Section 4 Elder Law Estate Planning Attorneys, as well as a small firm section head. Worked in every position you can at the state level. I trained other attorneys in and outside the state, and I belong to a very large community of elder law attorneys. So if you're not in Kentucky, that's okay. I can find an elder law attorney for you wherever you do live. What I say tonight is going to be specific just for Kentucky, because I think that's most of the audience. That's where I am licensed. Now, if I cross over into VA, I'm licensed for VA work across the entire nation. But with that said, I'm going to get down to business. We are an elder law firm here in Richmond. I love historic homes, by the way. There's couple of pictures of the homes that we have operated out of over the years. The top picture, that's one of my offices here in Richmond. We have another office over at Harper Square in Richmond, and are trying to open an office in the next 2 months in Laurel County down near London. And you can see the practice areas. We serve VA, special needs, guardianship, regular estate planning. That's sort of what we're talking about tonight. If you ask me about how to get out of a speeding ticket, I'm sorry. Don't know how to help you with that. I work just in these things. So now let's talk about the real topic. Wills versus trust, why one is better than the other. So what is a will first? A will is a description for why, while you're alive, you stating what your wishes are after you have passed away. And that's important because sometimes people think the will has some binding effect even before you pass away. So let's create a scenario to make this make sense. My dad is alive. My mother has passed away, but there's only 2 siblings, me and a brother. I'm the charming, smart one, and he's the really strong, rich one. So he comes to me and says, Scott, you're not supposed to get this or that from Dad. The will says I'm to get that. It doesn't matter what the will says. Nobody is going to follow the will until dad passes away. That's what we mean when it says it's binding only upon death. You can have a will, you can rewrite a will. And in fact, if that will, even if the whole family knew what that will said, if it gets lost, it's not of any value at that point either. Kentucky doesn't allow electronic wills. You can't record them at the deed vault. You've got to protect the will. It must be the original, and it must meet all the criteria to be found valid by the judge. Then it goes into effect at the end of your life. So that's what a will does. It doesn't do anything at all for other concerns that we would use a trust for, protecting privacy. A will has to be made public through the probate process. When you die, you go to court, it's made public. You can't keep secrets that I gave more to this child than that I had X amount of money. Every asset has to be disclosed. So there's no privacy, but there's no asset protection. There's no value for you in long-term care planning or anything else like that. So that's a will. Now, let's talk about some of its weaknesses. If a will doesn't go into effect until I've passed away, that would suggest that if I lose it, it's not helpful, it's gone, it's not going to apply, all of that sort of stuff. But let's go one step further. When is another time that a will would be determined to not apply? The first thing that makes what I'm getting ready to say make sense to people is without a will, Kentucky lets people inherit in a certain priority. And most of the time we think that if I have a married couple, this one passes, everything's going to go to the surviving spouse. That is not true. If you're married, your spouse does not inherit as first priority. Your children inherit as first priority, then your parents as second priority, your brothers and sisters as third priority, and if they have already died but had kids, the kids come in on their piggyback. So your nieces and nephews are fourth priority, and then your spouse comes in as number 5. Now, that's shocking to a lot of people, but here's the reason why. Imagine that grandpa's given the farm and it's gone down the bloodline, and all of a sudden Scott marries over into the Hatfield or McCoy clan. Now we've lost our priceless family farm over to that bunch of people that we've been feuding with forever. So we wanted to protect that. That's why spouses are the last one. We're going to have the spouses take that property, that money, whatever, into the other bloodline later. That's the rationale. Now, that's so harsh that the legislature decided, well, that's almost like disinheriting your spouse. And we know that we marry because we want to take care of each other. So that can't be the way. And so there's a change that says, even though spouses are fifth, they do automatically, they can assert a need or a desire for half. Even though they were fifth, they can take half. And so you get half along with the children. So imagine, like me, I had the unpleasant experience of going through a divorce, and I remarried a wonderful woman. She had children of her own. I have children of my own. So if I pass away, my wife is going to get half of stuff, and my kids are going to be joined to the hip with a woman that they are not related to other than the fact that I married her. And that can be very difficult, very problematic when you're trying to sort things out. And here's where it becomes really important. So take everything that I've said, put it over in a box for a second. Scott, none of this matters because I have a will, and I've already made it clear that children, stepchildren, all that's going to be all given very specific things. No, because of everything I said that's over here in the box, where there's spousal is fifth priority, everything to the kids. Kentucky's legislature came up with a second rule, which is even if you have a will, the spouse that survives can elect against a will. Let me make this clear by another illustration. I'll use myself and my wife. The office I'm sitting in is that historic Victorian 2-story house on Main Street, but I have a farmhouse that's 8 miles south of town. It's the house that my wife stays in. She loves that house. There's privacy. She likes to be outside. So I want her, if I pass away, to have that house. But I'd like my daughters to have this historic home And so I give one to my wife, one to my daughters. But my wife doesn't like that. She says, "Phooey on that. I want the Main Street house. All she has to do is say, I elect against Scott's will. My will is going to be thrown out. And my wife, regardless of it being absolutely valid, gets to say, my will is of no account, and I want 50% of everything." And then what tends to happen is my wife, being older, has more wealth accumulated. My children are younger, not as much wealth accumulated, so they have no way to buy out and get 50% ownership away from my wife. And so everything gets tied up in court, and it could go on for decades. The first time I saw this, the house had sat in probate for over 30 years because neither party could afford to buy the other out. That is why a will needs to be thought through very carefully, and often the primary reason that I say a trust is better than a will, because a trust cannot be elected against under any circumstances. Now, if you don't have children, or you'll say you're single, widowed already, there's no spouse to elect against it, there's all kinds of times where the will might be sufficient. But if you're married, if there's stepchildren, things like that, a will is a landmine waiting to happen, because it is often the case that once somebody passes away, disputes arise that we never thought about. And trusts provide a whole lot more security about that. So we're going now to talking about trusts. But before I do that, I want to pause right here, because what I've said, that's a lot of information, and I want to give you a chance to ask any questions.
Is a trust specific, or should I say only valid in the state that it was created? In other words, if I created a trust in Kentucky and later in life moved to Virginia and die in Virginia, is that trust created in Kentucky valid?
There are small exceptions where it might be considered invalid. And I can't give you an example of all of those because I don't know what, let's say, Oregon law is or anywhere else. But I have studied broadly to make sure that what we do is going to be valid in other states. So here's the answer. In almost every case, your will and or your trust is going to be valid in another state. If you had, let's say, a Texas will and you move to Kentucky, you call my firm up and say, "Scott, do I need to redo my will? Do I need to redo my trust?" What I want to do is review it first. I'm not going to tell you it's absolutely invalid just because you cross state lines. Just the same as if you purchased a car and you got a contract in Texas, is it still valid in another state? Sure. It's a contract. A court's going to look at it the same, but there could be different lawsuits that have happened in the new state. So it's worth talking to an attorney in the new location to say, "Hey, is there anything wrong with my Oregon?" But as a general rule, Oregon, Texas, whatever, you understand, I'm just coming up with a hypothetical. But as a general rule, it's going to be valid in the new state, but you do need to have some attorney just weigh in and say, "Is there anything about this special fancy aspect of my will or my trust that makes it invalid?" Now, let me give you an example, but absolutely for a will, I would encourage you to always have it reviewed, but you should most of the time say, "Oh, it's going to be okay." With the trust, it's a little bit complicated, but still it's going to accomplish the purpose for which you created it. So a little bit of foundation first when I get into talking about it. A trust is nothing more than a contract. When you go out and you start doing research, reading, internet, doesn't matter to me if you got it from a book or a website, you're going to start hearing jargon like legal entity. That just gets in the way of understanding the basics. A trust is nothing more than a contract. We understand a contract. Any one of you can have a contract with me that I will do your lawn on Sundays if it's not raining, in exchange for gravy and biscuits on Saturdays. There's no standard format for a contract. It's just one party gives, the other party receives. That's what makes a contract. That's what a trust does. So the important part about that is, even though I did this research myself, 138 different types of trust recognized under US law, it doesn't matter. You don't have to understand 138 different types of trusts. All you need to do is determine what your goal is. because all trusts are created, customized for the goal in which you're seeking to solve for. So if I am trying to, let's say, protect assets, that's one way that I might create the goal, then I have to have a certain kind of trust. If what I'm trying to do is reduce stress and avoid probate, that's a different kind of trust. So you always determine the goal first, and then you figure out the best fit, customize the trust to accomplish that goal. So let me finish this slide and then I'll make that clearer on the next one. Some trusts are used during lifetime, whereas a will doesn't become effective until you've passed away. The trust is effective during your lifetime, and it can do all kinds of things. Usually it's for ease of transfer, tax purposes, privacy, protecting assets, something like that. Now, when I start talking about these, I want to give you a few terms. We're always going to have a trust maker. There's all kinds of phrases for that, grantor, settlor, but the person that makes it, you've got a person that controls it. Sometimes that's a different person. Sometimes it's the same person. It could be the trust maker that's the trustee. It might be a different person that is the trustee. And then there's a beneficiary. It may be that your beneficiary is the same person as the trustee. It may be that the beneficiary and the trust maker are the same person. It may not be. All of this has to be customized for whatever your goal is. So a large number of trusts are created just to avoid probate. A probate is the process where after you've died, the government determines who's going to get what. If you have a will, the court's going to follow that will. And this is coming right back to Jeff's question. Is my will, is my trust still valid state to state? Well, the court's going to look at it and determine, is it valid under Kentucky rules? And then are the things it's trying to accomplish, giving this to Jimmy, giving this to Ralph, giving this to Tammy. The court's going to make sure those things occur so legally that new person truly does own it. Now, when you do a trust, you don't have to go through probate's a public hearing. If you have a trust, it's private. You don't have to do anything with the court at all. Transfer is automatic. So in this process, there's a certain kind of trust that is very popular. That type of trust is called a revocable trust. So let me skip ahead. Big categories out of those 138 types of trust. There are big categories of living trust or testamentary. That means I create it while I'm alive, or I create it through my last will and testament, and it springs to life after I've passed away. That's two categories. But among those types, you could also have one while I'm alive that's irrevocable, or one while I'm alive that's irrevocable. Or I can establish a trust that springs to life after my passing that is revocable or that is irrevocable, right? So all these different types. If you watch late night TV and you've seen Susie Orman on there, or you've seen Dave Ramsey on there, those two folks push revocable living trusts, RLT, all the time. Neither of them talk at all, really, but very little about an irrevocable trust. Irrevocable sounds scary. It sounds like, well, once I've done something, I can't get to it. It's not changeable. That's not what irrevocable means. Irrevocable is a shifting of authority. That's all it means, and that's too much for me to get into right now. Here's my point. RLTs, revocable living trusts, are very popular. They can be used in certain states, especially California, in ways to qualify for healthcare benefits. In Kentucky, an RLT will not help you qualify for healthcare benefits. At least once a month, I meet with someone who has, just like Jeff is suggesting, an RLT in another state, moves to Kentucky. They paid thousands of dollars for this RLT. Is it still valid in Kentucky? Yeah, it's valid, but it won't help you accomplish the goal. But not because the trust is invalid, but because the healthcare system in Kentucky for long-term care won't accept revocable trusts as an option, which just makes the point all the more clear. The type of trust is not what's important, the goal of the trust. And just because it accomplishes a goal in California or Arizona doesn't mean it'll accomplish the same goal in Kentucky. So before everyone's scared to death, I want to make 2 points to give you some peace of mind here. I've already said the first one. Go see an attorney. There's not a whole lot of cost at all to have an attorney do a review. Many attorneys are going to do the review for free or for just a couple $100s. Most of the goals that you're seeking to accomplish with a trust are going to fall into two categories: healthcare protection or probate avoidance. Those require completely different types of trusts. If you get that much from tonight, you're going to be in much better shape. Healthcare protection, long-term care, you got to have an irrevocable trust in Kentucky. If you had something somewhere else, an attorney didn't advise you correctly, sorry for that confusion, but that's the major breakdown that you need to be concerned about. So let me give you a little bit more on that. I keep coming back to this idea of you got to determine the goal first. So what are some of the goals we're talking about? The benefit of the trust could be all kinds of things. You could just want consistency. You want to avoid this problem about electing against the will. You want to avoid this problem of, what if I lose my will? What about if I am getting remarried or going through a marriage or divorce, both make your will at least partially invalid, if not fully invalid. So now, losing a spouse through death does not invalidate a will, but remarriage does, divorce does. If you want consistency so that whatever you determined back in 1980 in that will, well, the will is going to need to be updated regularly so that it remains consistent. A trust wouldn't have that same problem. It's also a tax issue. So let's talk in terms of relationship. A lot of times you'll find couples say things like, well, my partner and I chose not to get married because we get retirement benefits a certain way. It's going to be a better tax advantage for us. We're committed to each other. We've lived with each other for 20 years. But if you don't have a trust, what you're going to do is face a 16% tax on anything you leave behind for your spouse or your partner. So the relationship really matters. Trusts help a lot with taxes. In many cases, avoid taxes altogether. So that's another difference between the two. But most of the time, they're going to come down into the categories about, are we trying to avoid probate? Are we trying to make this transfer easy, keep it private? Now, easy means a couple of things, but let's say if I passed away today, how long is probate going to take? Probate in Kentucky requires a minimum of 6 months. However, probate also requires a tax filing. So since there's been income for Scott during the 2025 calendar year, guess when I have to wait to finish probate? Tax documents aren't going to be printed until January of 2026. So I've got at least a 10-month process before I can even file the taxes, right? Then the IRS has to go through the tax return, accept it. If there's a refund, a tax bill, a miscalculation, I'm probably going to be looking at something nearer June of next year. So a 16-month probate, and that's going as fast as you possibly can. If I have a trust, it's instant. As soon as the person passes away, you can get to work, disperse the assets, and life goes on. You can be done literally in 1 week instead of 16 months, right? That's a huge difference between the two. And that'll also figure in because people will often ask about cost. Well, if you got legal fees that go 16 months, do you think that it's going to be cheaper to have a trust that costs a couple of $1,000s? Yes, it will, because probate will often cost $15,000. I'd much rather get it done instantly for a few $1,000s here versus teens to possibly even $20,000 the other way. Now, the irrevocable trust, those are used for healthcare benefits, usually long-term care. And that's important because about 70% of us are going to need nursing home care before we pass away. And I know that's hard to believe. We all have this idea that I'll die peacefully in my own bed, but only for 3 out of 10 of us. We got 18 on the call tonight. So that means that we're going to have about 14 people of our 18 that need that nursing care. And on average, is needed for about 3 years of a person's life, which is about $320,000 of expenses at the current nursing home rate. Now, that doesn't mean I'm putting everybody in a nursing home. You could have nursing care in your home, but the cost is virtually the same. So it's a huge need to use irrevocable trusts, but at least you now understand the difference. Revocable, no advantage other than avoiding probate, ease of transfer, privacy. The other is for asset protection, has all these advantages of privacy and those sorts of things, but you also can accomplish healthcare benefits using those. Now, there's another one for both of them that I've not mentioned, and that's taxes. But I really want you to think about taxes in the revocable category, because when these were created and became popular in the 80s, it was primarily for tax advantage. Because up until 2002, if you had more than just a couple of $100,000, you would be taxed on your estate. There was an estate tax. Kentucky has a similar thing called an inheritance tax. But right now, if you die in 2025, unless you have an estate to pass on to heirs that's more than $25 million, you're not going to be taxed as long as it's going to grandchildren straight down the family bloodline. Now, if you're giving it to nieces, nephews, your next door neighbor's best friend's dog's mother-in-law, that'll be taxed. But the straight down the family line, no taxes. So revocable trusts for the purpose of tax avoidance are not that important right now. Now, could the laws change? Sure. But it's highly unlikely we'll ever go down to a taxable estate for anybody less than $6 million. And that ain't me. And for the most part, it's not you either, right? That's 1% that is always talked about. Now, I did say if you're not going down the bloodline. So if you have a partner, you're not married, sure, revocable trust. But you can accomplish the same thing in an irrevocable. A couple of myths about trusts, right? Trusts are for the wealthy. Trusts are not for the wealthy. Trusts are for smart people. That's who trusts are for. Yes, a lot of wealthy people have trusts, and they're wealthy because they're smart enough to use them. And if other people will start using them, you'll retain wealth too. And it doesn't matter if you just have $20,000 in the bank, your house is all you own. A trust can really save you a lot of money. I may give an illustration of that if people ask more questions, but I'm just going to leave that one there. If the will is enough to avoid probate, a will requires you to use probate. A will doesn't get followed unless you go through that probate process, which is then the legal fees, then the public announcements, then the 6-month waiting or more. So a will creates probate, not avoids it. And then people say, well, trusts are too expensive. I love this question because a trust will save you money. It is extremely rare that I've ever seen anybody put a trust in place and it actually cost them more to create it than the money it saved if they had not used it. It's just, they are expensive. Now, a trust is going to cost somewhere in the neighborhood of 8 to 10 times more than a will, but the will is going to require probate, and now you're going to pay several $1,000s worth of court costs, legal fees to go through the probate process, taxes on top of that. If you use the trust, no probate, no taxes, no time off of work, no headaches. It ends up that it actually saves you money, saves you trouble, all sorts of things. And there's always an exception, and I know all of us have a horror story about somebody who had one and blah, blah. But you could say that about everything under the sun. I had a friend who ate lasagna once, they died. What's that got to do with life? I love lasagna, and you can't change my mind on that. So I know there are myths out there, but most of it's just bad information. So let's open this up to questions. What have I raised so far? I can go deeper, but ask away. What's on your mind?
Scott, I have a question.
Yes, sir.
If you put money into a trust, is there a process where if you needed some of that money at a later date that you can have some of that funds back? And is there cost in that? What would be the process there? Or are you just locking that money in strictly for future beneficiaries such as your children?
It's a great question. People fear that. So I'm glad you're bringing it out so we can all clarify this. There are very few, out of 138, there are very few trusts that ever lock the asset up where you can never touch it. There is going to be a way to get the stuff back out of trust no matter what. The question is, how do you get it out? And this is where the goal and the type of trust would change that. I want to come back to that because that becomes a little scary and confusing. Let's just think about it this way first. If I'm using the type of trust that helps me secure long-term care benefits, when I place my house in there, for instance, trusts that I would create are going to say, you as trust maker have exclusive right to use that house forever. No one can kick you out. You can't be made to pay rent. That house is yours, and you retain not only the right to use, but you retain all of your property tax exemptions. So the homestead exemption, you retain that. You retain all your capital gain. And if you said, well, I want to sell the property, you can sell the property from within the trust. You could downsize, you could another one, put it in the trust. You can do anything you want with it. If you have cash assets in a trust, you can always invest them, do anything you want. So here's the rule. Anything an asset can be used for outside of a trust, the same thing can be done with it in a trust. But your question is, yes, but can I use it? If you have an irrevocable trust, what that means is that you can't touch it. You have to use an intermediary, a trustee. Usually that trustee is going to be one of your family members, let's say your children. And if you're willing to make that one concession where you put your stuff in this trust and you're willing to let your child, let's say, be the one that writes the check to pay for certain things for you, get cash back out for you, whatever the case needs to be, as long as you're going through them, that preserves the benefit that the trust is giving, that the assets, keeping it from being item that is counted in qualifying for long-term care benefits or anything else like that. But that's just the irrevocable type if you're trying to do healthcare benefit planning. If you have another type of trust, like a revocable trust, there's none of that applies at all. You treat that money just like it was still yours. You're the one writing the check. You don't even have to talk to the children about it. Got nothing to do with the kids. You're in charge of everything. But in neither case, because I just had somebody last week, this is what happened. Said, oh, it's locked up for 100 years. It's not locked up. You can do anything you want as long as you go through the one procedure that only the trustee accesses to get stuff out. Then it can be used for any purpose necessary. Now, you can restrict that. You can say, well, I don't want to, this money could never be used for A, B, or C. But unless there's a restriction, then you can access it and use it for anything you need to.
I want to build on that question.
Good. What else?
Okay, the scenario you created where it's an irrevocable trust. Daughter is the executor, for lack of a better word. And I go to her and say, hey, I'd like to buy a fishing boat. I'd like 50 grand. She cuts me a check. Does that show up as taxable income?
No, it's not taxable income. I would prefer her to do it. And again, part of this depends upon the type of trust. I'm trying to draw us a little picture that I'll share just to make sense of what I'm getting ready to tell you. It's not taxable income. That's one thing that gets confusing on this. And I'm going to go a little bit overboard to explain because I'm always concerned that people that are as proactive as you guys, you're showing up here, shows me that you really are proactive people. So if you leave here today and you do some research on your own, I don't want you going and reading some article that sounds like what I was talking about is not true. If you just research taxable distributions from a trust, you will find that trusts may be taxed at 37%. Just because they can be doesn't mean they will be. If you follow certain rules, the trust would be taxed at 0, but under most cases would not be taxed any higher than what your own personal income tax rate is. Now, let's think about your question. If the trust is going to be taxed for buying a boat, at the same personal income tax rate that I already had, why would I be taxed on my own money buying a boat for me? I wouldn't, right? If I got 50,000, I want to share your boat, by the way. But this $50,000 boat, paying for it out of the checking account, I've already paid taxes on that money when I earned it. So there's no tax at all. And I just go that extra step because it can be confusing. I mean, there are difficult things, and anything a lawyer touches is going to get more complex. So don't get scared when you read these articles about taxation. Trusts are only taxed on the gain. So let's say I have $100,000 in my trust and I put it into a CD. And boy, since CDs are up, right, we got 5% yield on a CD. At the end of the term, a year later, let's say the CD gives me $5,000 growth off my $100,000 investment. The 5,000 is all that could ever be taxed, and it would be taxed at my income rate. So let's say my income rate is 20%. Most folks are somewhere between 15 and 20, around 18%. So I'm going to pay 18 times 5. I'm going to pay about $800 tax on that $5,000 growth. But if I had expenses, the expenses offset the growth. So let's say I paid my property tax with that money. I'm going to pay the property tax anyway. So I'm not losing anything. That's why I have my money invested. So it'll produce growth. I use the growth for expenses that are necessary for the trust, and therefore my taxes go to zero. Now, I'm going to go deeper on that because people will start trying to be their own tax advisor and it'll get confusing. But you're not going to pay taxes if you follow the rules of the trust and you stay in contact with your attorney and your bookkeeper or whomever else is helping you out, CPA or something. Love that question because people are scared to death of taxes. The trust is going to save you money. Other questions? That's a great one. Let's do another. What's the procedure for establishing a will or a trust? Both exactly the same. I'm going to go and find the most brilliant, charming, handsome attorney on the block. That's me. And set up an appointment, and that attorney will walk you through the process that should be something like this. You need to have an interview. Who do you want to have receive the things, the inheritance out of the will? Who do you want to receive the things out of the trust when you've passed away? Who do you want your executor to be? Or if it's a trust, who do you want your trustee to be? In the trust conversation, we got to start with, well, what is the goal of the trust first? So you're going to have that kind of a talk, then interview with the attorney. It takes me several weeks to put one together for you. So you'd come back, let's say 30 days later, and do the signing. And I would educate you on how to operate the trust, do a follow-up where I help you go to the bank or to the investment company or whatever else it is to put the stuff in the trust. If it's real estate, we're going to do it the very same day we create the trust. That usually takes just a couple extra days, right? Maybe a week if you're having to talk to the investment company like Edward Jones or Fidelity or something like that. At that point, you're done. So let's say in the maybe 30 days, 5 weeks, you go from no protection to now you're squared away and ready to go. There could be more complex things where you could establish and make disbursements into a trust over years, but a very quick process. Most folks are done within a 30-day period. We go back to the trust or the text that are coming through. One, can an irrevocable trust be amended before death? There are usually ways to amend an irrevocable trust. Now, here's what's interesting. Irrevocable means you cannot terminate it. Most people think, well, you can't amend it. Neither of them are true. Almost every trust will have provisions where it can be amended, can be terminated, or any other thing. And even if it didn't say you can terminate under these conditions, the Uniform Trust Code adopted by the state of Kentucky says, yes, you can terminate a trust if it's less than $100,000 content without asking anybody's permission. You can go to all beneficiaries and with agreement between them, you can amend it. You could terminate it. There are certain conditions where you have to go before a judge and ask permission. Having said, all on the same page, we want to get rid of dad's trust. Can we? The judge says, sure you can. Stamp it, you're done. So yes, it can be amended. You just have to know what the law is, read the document, and see which ones apply and find the way through that. Reading another one here. Is there a length of time once I've done the trust before going into long-term care Medicaid? State can't get my assets. Okay. So we're getting into a question here that really is asking more about Medicaid law than it is the trust itself. But let me say one thing before I explain the question. This is bringing up the Medicaid 5-year look back. There is a way around the Medicaid 5-year look back, no matter what. We just have to do a customized plan for you at the time. And there's no way to explain what the right method is until I know a real life situation. So for instance, let's say I put my money in a trust today. I need Medicaid tomorrow. I'm going to have a different fallback plan because I didn't make 5 years. Then if I got 4 years down the road, still didn't make 5 years, but it's 4 years have passed. Different, depends on how long I go before I come up with a different strategy. But no matter what, there's always a strategy, okay? Really with this question, like I said, you're asking more about Medicaid, but here's the illustration. A trust is a whole lot like me robbing a bank. If I go across the street and I rob the bank and I take the money from the bank, $1 million from the bank, and I go home and I put it in my fireproof safe, is the money protected? Yes, it is. The fireproof safe protects it. Am I still going to go to jail if I get caught? Yes. And I'm giving you this silly, I'm not into robbing banks and I'm not into burning down houses, but I'm trying to illustrate something for you. The trust protects immediately. Medicaid cannot get the money from the trust immediately. The nursing home cannot get it immediately. It's instantly effective. But the Medicaid rule about the 5-year look back and how you get around the look back, those rules change depending upon the circumstance. So that's about as far as I can go with that until we have a concrete situation arise. But I would just simply say this. People are scared of the look back. It doesn't matter. You need to protect your assets no matter what. If you don't make 5 years, we can come back with a fallback plan. But we don't let the doubt or the lack of a crystal ball, because I don't know if I'll make 5 years or not. We don't let that lack of awareness change what the preferred method is. The preferred method for full tax benefit, for most flexibility, for the most ironclad safety possible is a trust. And if I don't make 5 years, then I have to do a fallback plan, which could be anything from an annuity to a reversal to other types of deed work to contracts. Anything else could work. But we start with the preferred method and then just develop a plan B, a plan C, whatever needs to happen there. I'm sure that's crystal clear. So go see an attorney. I'd love to talk with you if you want to go more into that. Let me go back to the top of the list. Let me see. I did talk about the will and how taxation, if a beneficiary under Kentucky, how there could be up to 16% taxes depending on which category they fall into. Distributions from a trust are not taxable. They are considered gifts, and the person making the trust doesn't have to pay any tax on that. It goes to that other person without tax, as long as it's less than that lifetime amount I mentioned earlier, which is 12.6 million per spouse. If there's two of you, it's 25 million. That's almost, it's 0.01% of the US. So beneficiaries of trusts not taxed. James asked another question. What information do I need in order to put children in there in the trust to receive? You don't need date of birth, social security numbers like that. I don't like anything that's that personal. If I simply say John Doe, let's say it's just a high school friend of mine, John Doe of Lexington, Kentucky. That's fine. Your attorney or your trustee needs to have the contact information, but just the name is sufficient. to make it legally binding. The contact information needs to be held privately by the trustee or some other person. Even if it's a family, you don't even have to be that specific, right? So let's say I want it to go to Scott's grandchildren. That's enough. If I have new grandchildren that are born, do I have to add their name in there and put them name by name? No, I don't have to do that unless I got a favorite or something, but that's all you need in there to make that work. Another good question here. What if there's real estate in an irrevocable trust? Can it be mortgaged by either the grantor or a beneficiary? It cannot be mortgaged by the grantor. It cannot be mortgaged by the beneficiary. It can be mortgaged by the trustee. So let's just say I need long-term care. My daughter is trustee. I've placed my house in there. We need extra cash. Let's say I need a handicap ramp. Can she get a mortgage against the house to add something to the house? Sure, she can. But that's the trustee's role to make sure those kinds of things are met. She's doing it for my benefit, but that's a provision allowed in the trust. She has to do the legwork, but we can still do all those kinds of functions. Love that question. Good question. Let's see, I'm down to if savings and investments are, if I have an insurance policy already says this goes to Scott's grandchild, I don't necessarily want to put that life insurance policy in the trust. It might be a good idea, it might not, but I just don't want to make that decision without thinking about it. The problem is that if I need the long-term care benefit through Medicaid, Medicaid is going to say that insurance policy, if it has a cash surrender value, it must be liquidated in order to pay for the care before the benefit would kick in. So you need to talk to the attorney on a case-by-case basis. What other alternatives do we have? We transfer the full policy? Is it better to switch it out for something? Do a prepaid funeral? There's all kinds of options there. But an insurance policy is going to produce a certain kind of strategy. If it is just a savings account and you've got a pay on death provision on your savings or checking account, it's still going to be a countable asset for Medicaid. If we're not trust and healthcare benefits, the answer is unless it's placed in the trust is not going to control it, and your beneficiary designation is. Now, depending on how the beneficiary designation is, it could still have to go through probate. So you want to be very careful about that. Talk to an attorney and get some direction on, is this asset going to be correctly administered without it being in a trust? So the bottom line is it depends, right? Let me see. That might be my last question. Anybody else got a raised hand or anything? You may have generated new questions that you've not asked yet. Thank you for being here. There is a couple of things. If you do scan this, I don't know if you know how to scan a QR code from a computer. This would take you right to the website. If you got more questions, right there's the phone number. You can call and make an appointment if you need to sit and meet with us. Thank you very much, ladies and gentlemen, for sharing your time with me. I appreciate you, and I hope to see you next time. Thanks for the thumbs up, sir. I appreciate that. You all take care. I wish you some pleasant weather over these next few days before it gets cold again.